Good afternoon. I'm Ted Hagelin. I'm the director of the New York State Science and Technology Law Center at Syracuse University College of Law. With me today is Professor Lisa Dolak, the Angela S. Cooney Professor of Law and the Senior Faculty Consultant to the New York State Science and Technology Law Center at the College of Law. Thank you for joining us for this discussion of a very important case, Uniloc versus Microsoft. Arguably, Uniloc is the most important decision handed down by the Federal Circuit regarding patent infringement damages in the last decade. Its importance really is twofold. One, it totally rejects the 25% rule, which was widely used in patent infringement cases. And two, sets forth some fairly clear criteria that the court will look to see in accepting damage methodologies in the future. Lisa's going to talk about the decision, talk about where it fits with other patent damages cases, and a little bit of some suggestions for patent litigators. I will then talk about the implications of Uniloc for negotiating patent licenses. Lisa.
Okay, thank you very much, Ted, and thank you all for joining us. We look forward to receiving your questions, and those can come to us two ways. We've got an email address there for you, nysSTLC@law.syr.edu. Alternatively, it's my understanding you can type them into the field, the Please Submit Questions field. And if you can do that, that would be terrific. And then we'll try to have some time at the end to hear your questions and comments. Okay. Again, Ted said I'm going to give you a little bit of a summary of the Uniloc decision. It came down on January 4th of this year. It was one of those, it sort of comes across your screen and it sits you right up because of its significance. This was an appeal from the post-trial motions, the district court's decision on post-trial motions in Uniloc versus Microsoft Corporation. And Microsoft had, in the alternative to winning on liability at the Federal Circuit, had asked that the district court's alternative ruling granting it a new trial on damages be affirmed by the Federal Circuit, and the Federal Circuit did that. The jury had awarded Uniloc $388 million. At issue for our purposes today is, as Ted indicated, the 25% rule of thumb, as it is so-called. And also at issue in this case was the expert's reliance, as we will discuss, on the entire market value rule, which he said he used as a check. And again, we'll talk about that in a moment. Just a little bit of basic damages background. We can think about a reasonable royalty as reached when a particular rate or a percentage is multiplied times some sort of base, a dollar amount. And then in some cases at least, in most cases, it's at least for complex products, it's appropriate to then apportion the amount that you receive by multiplying the rate times the base to account for the significance or the role that the actual patented component plays in the infringing product. And again, that'll become more clear, but just in terms of an outline, kind of an agenda for me, rate times base times apportionment. The 25% rule relates to the rate. And we start with the statute, 35 U.S. Code, Section 284, provides that a patent owner who succeeds in establishing infringement is entitled, again by statute, to at a minimum a, quote, reasonable royalty, and I've emphasized here a reasonable royalty for the use made of the invention by the infringer. So right in the statute there is a limitation imposed on the reasonable royalty that I think it's fair to say if you read some of the recent Federal Circuit damages cases, the court is expressing a concern that we've moved away from that limitation. We have to keep in mind that it is a reasonable royalty for the use made of the invention by the infringer. For a long time now, courts have relied on the so-called Georgia-Pacific factors, which is a 15-factor test that actually originated in, I believe it was a Southern District of New York opinion, and then was left untouched by the Supreme Court. But anyway, it was just kind of a district judge who started the ball rolling with respect to the 15-factor Georgia-Pacific test, and it is the framework for determining a reasonable royalty in litigation. The goal of the 15-factor Georgia-Pacific test is to, the courts tell us, estimate the outcome of a hypothetical negotiation between a willing licensor and a willing licensee. In other words, to try to imagine the deal that the parties would have reached instead of proceeding to infringe the patent. It's not quite that, of course. The law has to recognize, has to take into account that the patent owner, is probably entitled to more than what the parties would have agreed to in a sort of arm's length negotiation. Otherwise, it would often be in the interest of the infringer to just go ahead and infringe and not pay the royalty in the first place. So, but that's the general concept of the hypothetical negotiation. The 25% rule goes back, 50 years? It originated with a gentleman whose name is Robert Goldscheider, and even he designated it as a starting point for evaluating what should be an appropriate royalty rate. The basic theory underlying the 25% rule, as articulated by Mr. Goldscheider, is the assumption that, as between the patent owner and the licensee being the party who's actually commercializing the invention, at least, in every case, obviously, sometimes patentees are also commercializing, but in every case, if we're talking about a licensee who's going to make use of the invention, that licensee is undertaking some risk, commercialization risk. And so Goldscheider's theory was that the pre-tax profits, the revenues, ought to be allocated 75% to the licensee, 25% to the licensor in order to account for the fact that the licensee is undertaking that risk. And as Ted said, it had been routinely employed as a guide to a reasonable royalty in patent litigation, and therefore in negotiations, license negotiations. Now, turning a little bit to the base, again, you need a dollar amount to which to apply that rate. The entire market value rule is one way of determining the base. It is very attractive to patentees because it, as I say here, allows a patentee to assess damages based on the entire market value of the accused product. In other words, the revenues attributable to the accused product as opposed to the component invention. But first of all, the courts say it's only supposed to be invoked where the patented feature creates the basis for customer demand, at least in its in its pure form. And we have to keep in mind throughout this discussion that the patent owner bears not only the burden of proof on the issue of infringement, but also obviously the burden of proof on the issue of damages. So whether a patent owner in litigation attempts to recover lost profits or settles for the reasonable royalty to which it is quote-unquote entitled by statute, it has to prove those damages. And so inherent in this is the notion that the patent owner should have to prove that the patented feature is in fact creating the basis for customer demand before it even invokes the entire market value rule. Now that's quite controversial, as I indicate here, particularly when you have, as you do with many high-tech products nowadays, multiple component hardware, or as was at issue in Uniloc, multiple component software products at issue. Okay, turning to the actual decision, the patent was the 216 patent. It was to a system for software registration. The products at issue were, as I indicate, Microsoft Word XP, Word 2003, and in fact the Windows XP operating system. And so these are obviously very, very complex, multi-feature, that's the understatement of the year, products. And the particular feature of these products that was alleged to and established to infringe was the product activation feature. That verification that we've all done, where we've entered the code that comes on the software, in order to establish to Microsoft that we are using a legitimate and as opposed to a purloined copy of the software. So think about that for a moment. This isn't the feature that helps you even to change the case of your title from uppercase to lowercase or otherwise benefits in the traditional sense the user, the customer. This is a feature that benefits Microsoft in its efforts to protect its intellectual property. The district court, interestingly, at the pretrial stage, denied Microsoft's motion to throw out the 25% rule right then and there, and never let it go to the jury. The district court, though, referred to it even there as a perplexing rule under all the circumstances, but acknowledged that it was widely accepted, and so let it go forward, let Uniloc's damages expert, in other words, testify in reliance on the 25% rule. However, after trial, the court granted Microsoft's motion for a new trial, again, as an alternative, assuming that liability would be upheld, because, quote, in the words of the district court, the $19 billion cat was never put back into the bag. And we'll see in a moment how the $19 billion figure came into the case. The expert, Uniloc's expert, this is the methodology that the expert followed. And first it began with a Microsoft internal document, which was produced during discovery. And the document said, and I quote from the document, that this product key, the product activation feature, a product key is worth, in other words, to Microsoft apparently, worth anywhere between $10 and $10,000 depending on usage. So that came right out of Microsoft's mouth. The expert said, okay, we'll take the lower range. We'll take $10 as the value, right, again, from the horse's mouth of product activation. That'll be the base. We'll take the 25% rule. We'll multiply it by $10. So rate times base, we get to $2.50 per product. Lo and behold, there have been almost 226 million copies of these products sold. We multiply that by $250 each, and we reach $565 million. So that's what Uniloc's expert testified the jury should award. He further said that I need to take into account all of the Georgia-Pacific factors. So there was some testimony about those factors. Some of them, he said, would have indicated that number should be increased. Some of them would indicate that the number should be decreased. So on balance, it was a wash. I'm sticking to my $565 million figure, and that my analysis, in other words, of Georgia-Pacific confirms that my $2.50 per copy rate is correct. And just to make sure, he invoked the entire market value rule, but only as a check, he said, sort of as just a verification that his methodology was sound. He says Microsoft, and this is the $19 billion figure, Microsoft has earned $19.28 billion from its sales of these products. If you take $565 million as a fraction of $19 billion, you get to a mere 2.9%. 2.9% sounds eminently reasonable, and therefore $565 million is reasonable. So what struck me about this, and I said this to Ted last week, that, damages experts, in my view, and I've said this to my students, I mean, maybe it's because I'm not an economist, but the damages experts always seem to be the gods when it comes to patent litigation, and yet this is a fairly simple methodology, obviously, in this case. The Federal Circuit decision reviewing the...
Can I interrupt you just? There's a question here kind of related to what you were just saying.
Sure.
Do you feel that this decision effectively precludes accountants without economic education or experience from serving as damage experts because of the heightened focus on the application of the economic theory?
That's an interesting question, and one that I haven't, and I'm not sure, I don't know, I won't claim to know a lot about who qualifies now as a damages expert. I mean, I've been involved in some cases, I've seen some pretty impressive resumes and some pretty impressive experience. But I guess I would say that it would seem to me, and maybe Ted has a different view, that there will be the potential for a heightened emphasis on the economic expertise of damages experts going forward. So it may be harder. You may need to have a better qualified expert. better qualified in the particular sense that the courts are unhappy about, as we will get to, this notion that the expert testimony has to be tied to the particular facts, industry, products at issue. And so in that sense, it may be more challenging to get an expert qualified. Okay, so what the court said about the 25% rule first, the court noted several areas of criticism. It acknowledged that the rule had been under attack for a long period of time, and the court identified 3 ways that it regarded as significant in terms of that criticism. First, quoting the court, it fails to account for the unique relationship between the patent and the accused product. Second, the court said, it fails to account for the unique relationship between the parties. And in this regard, as you can see, I quote right from the opinion, Professor Hagelin his work in the Texas Intellectual Property Law Journal in 2004 was cited by the Federal Circuit. And the court said that Professor Hagelin noted that the rule should not be used in isolation because it fails to account for the different levels of risk assumed by a licensor and licensee. In other words, all these situations are not, are not necessarily 75-25% splits in terms of the risk. And then finally, the court said the rule is essentially arbitrary and does not fit within the model of the hypothetical negotiation within which it is based. The court further said that it has passively tolerated the use of the 25% rule where its acceptability has not been the focus of the case. And then this was the money language that Professor Hagelin mentioned at the beginning. As a matter of Federal Circuit law, the 25% rule of thumb is fundamentally flawed for determining a baseline royalty rate in a hypothetical negotiation. Evidence relying on the 25% rule of thumb is thus inadmissible under Daubert and the Federal Rules of Evidence because it fails to tie a reasonable royalty base to the facts of the case at issue. And there we have really the key lesson from Uniloc. It's an utter repudiation of the 25% rule to say that evidence relying on it is completely inadmissible. I mean, think about that. That's not just saying that other factors need to be taken into account. That evidence is now inadmissible, and the reason is its failure to tie a reasonable royalty to the particular facts of the case at issue. So an emphasis on the environment of the case at issue. Going on in that regard, the court said the rule does not say anything about a particular hypothetical negotiation or reasonable royalty involving any particular technology, industry, or party. The facts of the case at hand are what matters. This court's rejection of the 25% rule of thumb, however, is not intended to limit the application of any of the Georgia-Pacific factors. So we have, in essence, a reaffirmation of the relevance of the Georgia-Pacific analysis. But evidence purporting to apply to these and any other factors, again, must be tied to the relevant facts and circumstances of the particular case at issue and the hypothetical negotiations that would have taken place in light of those facts and circumstances at the relevant time. The court also said some things about the base side of the equation, the entire market value rule. The court said this case provides a good example of the danger of admitting consideration of the entire market value of the accused product where the patented component does not create the basis for customer demand. And I know that Professor Hagelin's going to have some things to say about this going forward, but for now it's helpful to remind ourselves that, again, this particular feature, as the court said here, Uniloc conceded, the patentee conceded in this case, the customers do not buy the software products at issue because of the product activation feature, right? I mean, that, again, is a feature that benefits, at least in the first instance, Microsoft and not directly the purchasing customers. So the court's saying, of all the cases in the world where the entire market value rule doesn't seem to be relevant, it's a case like this. And then, with respect to the $19 billion cat, the court says the disclosure that a company has made $19 billion in revenue from an infringing product cannot help but skew the damages horizon for the jury, regardless of the contribution of the patented component to this revenue. Okay, so before we turn to a discussion of the litigation and licensing implications of this decision, I thought it was helpful to, as Ted said, put it into some context. Uniloc is a very notable decision, but there had been rumblings of seismic change in the field of patent damages for several years now, and I'd like to point out that it all began, many say, right here in little old Syracuse, New York, in the federal courthouse in the Northern District of New York in 2009, when federal circuit judge, now Chief Judge Rader, actually sat by designation as the trial judge in the case of Cornell University versus Hewlett-Packard. Interestingly, this is a case where we can focus on the appropriateness of relying on a product as the base. The accused products were Hewlett-Packard servers and workstations, but, and again quoting right from Judge Rader's opinion, the claimed invention is a small part of what's known as the instruction reorder buffer, which is a part of the processor, which is a part of a CPU, which is a part of a brick, which itself is only part of the larger server. So you can see there that Judge Rader was trying to make the point that this is, it's like a set of those Russian dolls. You know, you've got the smallest component. And yet Cornell argued that the relevant base was the actual server. And so Judge Rader refused to let that go forward, but the award ultimately was based on the value of the entire CPU brick, not the invention or the IRB or even the processor, but the brick, and that resulted in a jury award of $184 million, which Judge Rader reduced to $54 million, saying that the processor revenue was the appropriate base. Back at the Federal Circuit, in this case, which was also a notable decision in 2009, Lucent versus Gateway, this case actually, as you will see, had both rate and base problems. The accused product, again, Microsoft Office Outlook. We're all familiar with the email program Outlook. The invention, think about all of the complexity of Outlook, for better or for worse, and the accused product here, the invention actually related to the little date picker. You know, you click on something, a calendar pops up, and you click on the date. So that's obviously a small aspect of the entire vast Microsoft Outlook software. The parties agreed on an $8 billion base based on sales of 110 million copies of Outlook. Lucent said, okay, we're going to apply 8% to that $8 billion. That'll get us to $561 million. The jury gave them $358 million, but the Federal Circuit vacated that award, noting both, again, base and rate problems. With regard to rate, Lucent's claim of entitlement to 8% was based on so-called comparable licenses. This is how parties often try to establish a royalty rate. You know, again, starting from the 25% rule and then trying to put in some evidence of relevant licenses. The court said Lucent's comparable licenses weren't comparable. Some of them were lump sum licenses. Some of them were running royalties. And the court said that, and what happened here was the jury actually awarded them lump sum damages. And so on appeal, Lucent was left to try to defend the evidence supporting the lump sum royalty, because a running royalty was now out of the question. And as to those lump sum agreements, the Federal Circuit said they were either insufficiently described or they were not for comparable situations. Furthermore, the damages expert conceded that there was no evidence that anybody, anywhere, at any time ever bought Outlook because it had a date picker. And so there you've got a ding on the entire market value rule. And the Federal Circuit said, furthermore, you know, if you are going to rely on the entire computer, which is, you know, the way a lot of people buy Microsoft Outlook, they buy a computer on which it comes loaded. Even if you run that royalty rate all the way down to 1%, if you're basing it on the entire computer, it's still per se excessive. RescueNet, Federal Circuit 2010. Similarly, the Federal Circuit vacated a $506,000 damages award, which was based on a 12.5% rate. Again, the product was software. The Federal Circuit said the award was based on speculative and unreliable evidence divorced from proof of economic harm linked to the claimed invention. So we've got the same kind of issues that are underlying the court's decision in Uniloc: speculative and unreliable evidence divorced from the facts. And again here, the allegedly comparable licenses, the Federal Circuit said 5 of the 7 related not just to software licenses, they were software service bundles. So, and the services provided had to account for a lot of the license rate. WordTech, another Federal Circuit decision from 2010, vacated a lump sum award in the amount of $250,000. The Federal Circuit, again, focused on the evidence that the patentee proffered, which was 13 previously granted licenses on some or all of the patents at issue. The court said that the proof lacked key information, including how the two lump sum amounts in those 13 licenses were calculated and the nature and number of the licensee's intended products. So if you're going to rely on licenses, they have to be comparable, and it's the patent owner's burden to establish the comparability. And here the court said that the patentee had failed to account for the technological and economic differences between those licenses and the situation at hand. So just briefly on some quick litigation lessons, I mean, just based on what I've already said, these will not be earth-shaking. They probably are all pretty obvious. But again, the focus, the court is saying we need better evidence from the patent owner. The evidence offered by the patent owner will be closely scrutinized. Comparable licenses have to, in fact, be comparable if you're going to rely on them, or at least expect scrutiny from the courts. And things like, in manners like lumps, whether they're a lump sum or a running royalty, what products were covered, what patents were covered, what was the relationship between the parties who negotiated those licenses, and what was the circumstances that yielded the license. And in particular, and it has long been the case, that obviously there are licenses and then there are licenses. There are licenses, as I mentioned at the beginning, that resulted from a true arm's length negotiation that the parties decided was in their interest, absent or at least ahead of litigation. And then, of course, there are licenses that are the product of litigation, and that can make a big difference, the court's reminding us. As for the entire market value rule and the so-called multiplier or that apportionment factor that I mentioned at the beginning, again, the courts are going to insist on reliable evidence linking, first of all, demand for the product to the patented feature, and then secondly, with regard to the apportionment, the incremental value that the patented feature affords the product. And the kinds of evidence that people are talking about that can be potentially relied on to make this kind of showing would be, for example, sales data and price data for products with the feature versus products without the feature, like first-generation products and then without the feature and second-generation products with the feature. So those kinds of comparisons. The courts have indicated, perhaps in dicta, perhaps consumer surveys, focus group testing, again, to show that the demand is what was driving the purchase and to what extent. Internal company documents, like we saw in the Uniloc case, Microsoft's own document, as well as industry, third-party documents, industry and trade reports. Finally, I think it was in the RescueNet case, the court, the patent owner on appeal tried to say, well, the defendant didn't rebut what we put in. The Federal Circuit there said that the defendant hasn't offered rebuttal evidence is not a make-weight for the patent owner in terms of satisfying its burden. And I'll turn it over to Ted.
Thank you, Lisa. That was great. I'm going to talk about the implications of Uniloc for patent licensing. And I'll begin by stating the obvious. The Federal Circuit holding in Uniloc has no binding effect on licensing negotiations. But I think it clearly has implications for licensing. The issue in Uniloc was, after all, the proper determination of the outcome of a realistic licensing negotiation between a willing buyer or willing licensor and licensee. Dubert, we're saying? Daubert. So Lisa actually looked this up, and the family pronounces it Daubert. So I'm going to pronounce it Daubert. I've heard it pronounced many of the ways, and that's certainly not the French pronunciation, but we're going to call it Daubert. And the court says Daubert requires that the damages methodology be tied to the particular facts of this hypothetical negotiation. So the decision in Uniloc clearly was in the context of what one would expect in a realistic license negotiation. As Lisa said, there are two issues in determining the value of a patent and the value of a license, the royalty base, the dollar amount on which royalties are calculated, and the royalty rate, the percentage amount of the royalty base which are paid in royalties. The Federal Circuit held that the royalty base must take into account the contribution of the infringed patent to the accused product sales, or what is often referred to as the incremental product. And the court said that there was no evidence that the product activation feature, the infringed patent, was the basis for customer demand for the accused products, as Lisa said. And the implicit assumption there, I think, is that the product activation feature had no value whatsoever and therefore made no contribution to the sales of the Microsoft products. In the context of licensing negotiations, I would suggest that the Federal Circuit decision may both underestimate and overestimate the royalty base. I think it underestimates the royalty base because the product activation feature may not have formed any direct basis for customer demand, but in the absence of the product activation feature, one would assume there would be widespread piracy of Microsoft products, which one would assume Microsoft would try to recover by virtue of increasing the price on the lawful purchases of Microsoft, and that increased price clearly would have directly affected the customer in that sense. So I think in that way, the court may have underestimated the value of the product activation feature. In terms of the court's overestimation, I think it's important to keep in mind that a firm must earn a rate of return on all of the firm's assets. Those assets include tangible assets, intangible assets such as management skill, employee training, as well as intellectual property assets. And intellectual property assets include both reputational intellectual property, trademarks for example, and technical intellectual properties. So I would suggest that before you get to trying to figure out the contribution amount to the sales, that it's important to think about disaggregating those sales to find the portion of those sales attributable to the technical intellectual property assets in order to calculate a proper royalty base. The Dubert calculation of a royalty base, therefore, I think this is consistent with the holding in Uniloc, would be the royalty base equals the total sales times the percentage of sales attributable to technical IP times the percentage of sales attributable to the infringing patent. The percentage of sales attributable to an infringing patent can be calculated by comparing the competitive advantage of the infringing patent to the accused product and the competitive advantage of a comparable patent to a substitute product. And that is the kind of a comparison, I think, that can be done. You can do that by way of customer focus groups. You can do that by way of different performance parameters. But you certainly can make those kind of comparisons in order to find out the relative contribution of the alleged infringing patent compared to a comparable substitute patent. The royalty rate, definitely not the 25% of the licensee profits, no matter how the royalty base is calculated. Again, the holding in Uniloc is in no way binding on licensors and license negotiations, but I would expect that going forward, a licensor seeking to assert the 25% rule as a starting point in a license negotiation will get the same kind of pushback on the same reasons as the court found in Uniloc. A realistic royalty rate, and again, this is, I think, completely consistent with Uniloc, should reflect three factors: the degree of risk assumed by the licensor and licensee, the amount of pre-license and post-license investment made by the licensor and licensee, and a fair division of the patent value between the licensor and the licensee. The degree of risk assumed by the licensor and licensee, well, there are three types of risk that anybody familiar with licensing would identify. There's the technical risk, the intellectual property risk, and the market risk. Technical risk is largely a factor of the technology state of development. Where is it in the development curve? Intellectual property risk is largely a factor of the strength of the patent being licensed. And market risk can be defined a number of ways, but certainly the number of firms in the markets and their market shares are important factors in determining market risk, and you can combine these risks to discount expected future sales. And note that in the case of a lump sum payment, the licensor passes all of the risk onto the licensee. In the case of running royalties, the licensor and licensee will share these risks equally going forward. The amount of the pre-license and post-license investment made by the licensor and licensee. The licensor's pre-license investment is what the licensor has invested in developing the technology and developing the patent in terms of internal costs, salaries, equipment, and overhead, and as well in terms of external investment by way of grants, contracts, and awards. From the licensor's standpoint, that should be the licensee, that should be the licensee post-license investment. It's the internal time and resources required to bring the technology to market, as well as any external grants or contracts which the licensee might receive, for example, in an SBIR or STTR award. In terms of the division of the patent value between the licensor and licensee, I would suggest that an ideal division of the patent value would provide the licensor and the licensee an equal rate of return on their respective investments in the technology. And again, if you take into account the technical market and intellectual property risk I mentioned earlier, you can apply this to a risk-adjusted value of the patent. And a Daubert reasonable royalty rate, therefore, I would suggest, would be the licensee's rate of return on the investment, which is the royalty payment that the licensor receives minus the licensor's investment, divided by the licensor's investment, equals the licensee's rate of return on the investment, calculated as the patent value minus the royalty payment minus the investment, divided by the royalty payment plus the investment. And I think these very simple rules, comply with Uniloc, and I think really produce a licensing negotiation that is very consistent with what the court was talking about in Uniloc. Finally, I just want to mention, sort of follow up on Lisa's the question about whether or not Uniloc is going to require much more sophisticated testimony. Even with the 25% rule, most of the people testifying are PhD economists, etc. I'm not sure whether or not the qualifications of the person are as important as the methodology that the person is asserting in the case. I think that's far more important to the court. And so you can have Dr. Gemini, who was our expert witness in Uniloc. We didn't check to see what his PhD was in, but he has a PhD in something. And as Lisa noted, it was a fairly simplistic evaluation, and clearly the court was underwhelmed by Dr. Gemini's PhD and much, much more concerned with the methodology that Dr. Gemini employed. So that's my piece, and we're happy to take questions.
We have stunned our audience
We
into
have stunned
silence.
our audience into silence. We'll wait a few minutes, but if there are no questions, we, of course, are available to take questions after the webcast. And you can mail them to Molly, and Molly will forward them. You have the STLC email address.
Since we have the time, if I could, there's a couple of things that I didn't manage to get into my slides that I thought might be worth talking about. One is that I talked about the Lucent case, and I think perhaps, that case has also gotten a lot of press. So I think it's fair to say it's also regarded as one of the more significant of the Federal Circuit's cases on damages in recent years. There is a statement that was written by the judges, the panel in Lucent, that has continued to generate controversy, and it relates to the entire market value rule. And the statement was that the base used in a running royalty calculation can always be the value of the entire commercial embodiment as long as the magnitude of the rate is within an acceptable range as determined by the evidence. So I think you can see why that's a controversial statement. For the courts to say that the base can always be the value of the product, the revenues from the sale of the entire product, in other words, as long as the rate, which, I think what the courts there are trying to say, that both the royalty rate and an appropriate multiplier are small enough. But as you can see, that's controversial even in the context of this case, in the context of the so-called $19 billion cat. And there have been those who have argued that as long as the patent owner is free to, quote, throw out a big number, there is the potential for prejudice in terms of what the jury will hear and what the jury will evaluate. And I'm raising this as a segue because that kind of language, although it comes in one of these, what you'd call as a recent sort of damages reform decision, is being pointed to by some who are advocating for perhaps congressional activity with regard to damages. And I'm sure that our audience is well aware that damages have been probably the most controversial aspect of the various legislative efforts to reform the patent system in the last, it's now 5.5 years, that there have been omnibus patent reform bills introduced in Congress. And in many respects, damages being one of them, but in the areas of, for example, willful infringement, inequitable conduct, there has been an argument that as the courts have sort of fixed these problems, the need for congressional action has decreased. And so the question is now being debated whether what the courts have done with respect to damages is enough to fix if you perceive these as being problems before or not. And I think, the way that some are arguing is that even if the only thing that ends up being in patent reform overhaul legislation is, as has been in recent bills, the so-called gatekeeper provision, which would specifically direct the district courts to be the gatekeeper on evidence and to make sure that the evidence is relevant in that it relates to the facts, circumstances, products, industries, patents, comparable licenses, those kinds of things we've talked about, and reliable. And obviously there's some overlap between relevant and reliable, but not necessarily exclusive overlap, that would be helpful because some have argued that even if this issue has the Federal Circuit's attention now, as it clearly does, that it may not have the attention of the district courts around the country to enough of an extent, and that if you pass some legislation and it's there in black and white in U.S. code, the district courts might be more inclined to be policemen. There's been some unhappiness in some federal litigation, on the parts of infringement defendants, obviously not in the parts of necessarily in the part of patentees, that, for example, some motions in limine, like we saw in this case, in the Uniloc case, regarding limitations on damages experts and their testimony, have fallen on deaf ears. The courts, sometimes are inclined, busy district court judges are inclined to say, let it go to the jury, we'll sort it out later. And that a gatekeeper provision might cause a busy district judge, or might call his attention or her attention to the need to police evidence up front.
Great. We now have some questions, and Molly Zimmer is going to read the questions so everyone can hear them. Molly?
Okay, I just read an article in the ABA's publication Landscape which stated the median patent infringement award was $10.1 million. Do you think the Uniloc holding will reduce this number, and if so, by how much?
So I think the average patent infringement damage award will go down. How much, I can't say. But to the extent that the 25% rule was so widely used, and the 25% rule in many, many cases, as well as the entire market value approach, inflates patent damages, my guess would be that those damages, average damages, would go down. Lisa?
Yeah, I mean, I won't surprise me. It's hard to say, right? Because, yes, it will certainly, I think, tend in more cases than in not to have a depressive effect. Beyond that, I mean, these average figures don't, I find them a little bit disturbing, right? Because they distort the picture. I mean, you can't just, they're not relative to anything, right? As product values, every case is different. And so the numbers aren't what's important. But I think I agree with Ted that it seems that on balance, the court's decision will exert downward pressure.
Okay, next question. How do you assess royalties or license arrangements if there is no revenue from either company, but rather gaining market share, which later can attribute to a revenue model, i.e. being acquired by a larger conglomerate or enough market share in an industry to attract advertising or subscription revenue?
Okay, so if I understand the question, it is how do you value a patent or a technology prior to the point that that patent or technology is incorporated into a product or is the subject of a license. And there, I think you still can nonetheless look at that technology and do a competitive advantage analysis comparing that technology to a comparable technology in a similar product. I think that's the way you have to go about doing that. And you can, of course, extrapolate from sales of the comparable products and predictions of the market sales going forward. But I think that's what you have to do in order to do a credible evaluation of an early stage technology. And I should add, I don't know how you take into account the possibility of being acquired. I don't know any damages expert that can do that. How you figure out that one media blog can buy out an established magazine. I don't know how you predict those kinds of things, but you can get your arms around a prediction of the potential sales and then look at the competitive advantage valuation and use that to sort of predict what those sales will be.
I guess I won't ask if you have any suggestions about competitive advantage method.
No, I don't.
Okay, next question. Surveys and focus groups, while having a solid foundation in other IP cases, trademark and false advertising, but not in patent cases. Asking consumers about an isolated feature can be difficult. Is it your opinion that the courts will view survey evidence as better than nothing, or will surveys, focus groups experience the same level of scrutiny as in other IP cases?
I guess, and this will be a little bit of editorializing. First of all, I expect, yes, I think that courts, again, sort of across the board will view them as better than nothing. But I agree and have experienced myself in trademark cases with the scrutiny that courts should and have become accustomed to doing of survey methodologies in trademark cases. And I would certainly hope and expect that that same kind of scrutiny would be brought to bear on any kind of survey or focus group evidence in patent cases as well. But I will point out that as I believe that the reference to surveys and focus groups came right out of its dicta in one of these Federal Circuit opinions. So it was actually the court saying, it may have been Judge Rader in one of, he sat by designation in another district court case that I didn't include, but it was a judge who said, in terms of how we're asking for all this evidence from the patent owner, and threw out some possible suggestions. So that wasn't Lisa Dolak talking; that was a judge.
And I just add that the survey, I think, is very useful in the context of a patent damages issue. I'm not sure it's very useful in terms of a licensing negotiation. I don't see parties going out and conducting a very, very expensive kind of a survey in order to get a better handle on the value of the license.
Okay. How do the Georgia-Pacific factors play into the adjustment reached by the formulas?
Well, and I don't even have a full set of them sitting in front of me, but just trying to remind myself of some of them. I mean, you know, the factors are wide-ranging. So while it was it was kind of a breakthrough methodology, the good news about Georgia Pacific is it allows for, and this is why I think the courts like it so much, it allows for the tailoring or the taking into account in any given situation of all kinds of things, some of which will be relevant into some circumstances and others won't. For example, some of them include, for example, the established profitability of the product made under the patent, its commercial success, its current popularity, the utility and advantages of the patent property over the old modes or devices, the nature of the patented invention, the character of the commercial embodiment as it is owned and produced by the licensor, the benefits to those who have used the invention, the extent to which the infringer has made use of the invention, I mean, on and on. And so I think one of the implications of this decision might be, to the extent we can't rely on the 25% rule at all, let alone as a starting point or as a crutch going forward, there may be a renewed sort of emphasis on the Georgia Pacific test. And it would strike me as likely that experts for both sides will mine those Georgia Pacific factors for those aspects which are helpful to them. But they are very fact-based.
Very fact-based, and I would add that I think the Georgia Pacific factors taken as a group really, number one, clearly look at the incremental contribution of the alleged infringing patent to the product sales, and in the aggregate, really do represent a series of questions that inquire into the competitive advantage which the alleged infringing patent contributes to the accused products.
The next question, which I'm not sure I'm understanding completely, since patent prosecution is apparently CA 94% of the expenditure on patents, why do we spend so much time on the litigation aspects, both in presentations such as this and the proposed legislation?
So the question, as I understand it, is the author of the question is asserting that about 94% of the cost of
expenditure on patents, patent prosecution is apparently 94% of the expenditure on patents. So why is there this emphasis?
So 94 cents out of every dollar that's spent on patents. The question is asking, or spent on prosecution, why the emphasis on litigation? Well, I mean, I guess maybe I don't understand the question either, but to me, I mean, the most straightforward answer that I can articulate is that, just getting the patent is, it's not even half the battle. I mean, patents are not worth anything. They're not worth the paper they're printed on.
That's right.
If they have no relevance to the marketplace.
Right.
And so, and it is under the statute, and of course in our civil litigation tradition, the burden is on a plaintiff. I tell my civil procedure students, sometimes they don't like hearing this, but it's the plaintiff's burden to not only establish every element of the cause of action, but also the damages. And so, in that sense, and I guess I would say in terms of the emphasis here today, I mean, obviously it was a decision of the Federal Circuit reviewing a district court's treatment of a adjudicated infringer's motion challenging the jury verdict. So, I mean, that's the context that we're in. But aside from that, these are, I mean, the fact that there are 15 multi-part Georgia Pacific factors and all of the kinds of things that Ted said, this is an enormously complicated undertaking. And so, naturally, it's going to be a very expensive analysis to undertake. I mean, damages experts, I mean, anyone who's ever been involved in patent litigation knows that it's not only the sport of very wealthy kings, but a big chunk of change goes to the proof of damages for good reason, I think.
And I would argue that I agree with Lisa that I don't want to minimize the cost of patent prosecution, but I would argue that the cost of patent prosecution is a very, very small cost in terms of the research and development that goes into the technology prior to the point of actual or constructive reduction to practice, and the amount of investment that goes into the technology post-license to actually turn it into a commercially viable product or process. So that's where the real investment comes in. I don't think it is in terms of the cost of the patent prosecution.
As steep as it is.
As steep as it is.
And thank heavens for that. No, I'm just kidding. I'm kidding.
Okay, now this says, so I can imagine using the ROI formulas and using the Georgia-Pacific factors for adjustment of royalty rate or damages. Do you agree with that?
Yes, I think so. Yeah, yep. Again, I like to think about the sort of three types of risk and the differential investment made by the licensor up to the point of the license, and the amount of investment that needs to be made by the licensee after the license. But I think you can certainly look at those return on investment and try to make those equal and work in the Georgia-Pacific factors, yes.
Okay. It seems misplaced to look at this as a feature that end users demand. Shouldn't the approach be that Microsoft is the customer and their demand was huge as shown by their piracy losses? As for the value to Microsoft of preventing those losses to piracy, Microsoft provided the valuation in its internal documents, 10 to 10,000. So that does seem to be the place to start.
Yeah, I mean, I think Ted's criticism of the court in that regard is well placed. I mean, what these circumstances in this opinion and Ted's criticism emphasize or indicate is that, you know, in some ways the point the court is making, that every circumstance has to be evaluated on its own merits, its own circumstances. There are some features that, I mean, maybe you don't buy Microsoft Word. You certainly buy Microsoft Word if it couldn't process text. You know, I think it's fair to say not too many people would buy it. I mean, that's what we buy it for, right? Then there's all this other cool stuff that it does. And maybe you wouldn't necessarily not buy the word processor if it didn't have that in there. But and then, of course, you've got this kind of situation where the feature, you know, doesn't really relate to consumer demand, but nonetheless has value. As the author of the questions indicates, it clearly has value. Microsoft recognized it had value, and as Ted has argued. So I think what the court was doing in Uniloc, you know, it was a nice circumstance. It was a nice set of facts to drive home the point. It was like it was the kind of thing we'd use in a law school hypothetical, right? What if the feature could not possibly be shown to drive customer demand for the product, right? And so I think the court, while really focusing primarily on the rate side, the 25% rate rule, you know, the fact that the expert had done this entire market value calculation as a check gave the court the opportunity to kind of make another point, as one in a series of cases, about not the dangers of the entire market value rule, but, you know, it was a dramatic way to drive home the point that we got to also be careful about the base.
And I would agree, but I think whoever's asked the question, I think that's another approach that could have been taken here. One, whoever in Microsoft who allowed that memo to be written ought to be fired yesterday. But beyond that, I think, yes, I think you could look at Microsoft as the direct customer, bring in evidence of what you think the piracy rate would have been in the absence of the product activation feature, how much that would have cost Microsoft in terms of lost sales, et cetera,
what that would have added to the price of the product.
And what that would have added to the price of the product, and that was sort of my point, but I think you could also just say what they would have lost. And I think that would have been a fair inquiry, but that's not the way the damages expert in Uniloc proceeded, and that was what the court had before.
Right, and that's the important point, is that courts don't remake what happened at the trial. The court sits as a court of review, and it has to review, and the question for the court is only whether the jury verdict was supported by the evidence or not. And
So we have a number of more questions, and we're happy to continue. If those of you who have to leave right now, thank you very, very much for joining us. But for those of you who have questions and you want to stay online, we're happy to go forward and answer a few more of these questions.
Okay. Theoretically, the damages can be over 25% as well. Does this weaken or strengthen a value of a patent, in your opinion?
the case, I wonder if the question is, does the case weaken or strengthen the value? I mean, it's certainly the case. I mean, and the original Goldscheider methodology was, again, 25% was a starting point. I mean, I think, it's fair to say that perhaps some of the criticism that methodology, the 25% rules received, is not fair because, again, he called it a starting point.
Right.
You have to start somewhere. And yes, the concept was that in some cases it could be more than 25%,
right.
and it certainly could be.
Right.
And,
but again, I think you would have to establish that in terms of the competitive advantage or incremental profit contribution of the alleged infringing patent to the accused product. And if in the pharmaceutical space, for example, where you do not have many patents packaged into the same device, there you could easily see an award that would exceed 25%. But that's nonetheless, you got to disaggregate that out.
Okay. This asks if the 25% rule used, is it a base formula?
I don't think the 25% rule will ever be admitted into evidence again in federal court. I think it is absolutely dead on arrival.
at least it shouldn't be.
And then there's a question about whether this will be available, and we will archive it and post it on the NYS STLC
Yes, we are filming
website.
this, and this will be on our New York State Science and Technology Law Center webpage, along with lots of other very, very useful information and lots of other conferences and video that we've done over the years. And so I encourage you to look at that webpage, not just for this particular webinar, but for a lot of other events that we've done, including presentations by Professor Dolak.
I think that's it. So thank you both very much.
Thank you.
Thank you all.